Section 25 on one hand talks about opposition to the patent, but as per Section 25 clause 2, the limitation to oppose the patent is only for the 1 year after the grant of the patent. But what about the case when the 1 year has been elapsed? In those cases, another provision enshrined in Section 64 of the Act states that any person interested or the central government or through a counterclaim in a suit for infringement, a patent can be revoked. Grounds for revocation of a patent are as follows. If any of the claim in the present patent is that which has already been claimed in an earlier patent and is a valid claim, then that will become a ground for revocation. Apart from it, if the patentee is not the entitled person to the patent, then it's another ground for the revocation. The third point states that if a patent has been wrongfully obtained or has been obtained on false suggestions, then that is another ground for revocation. For example, if an inventor or an employee of the rightful owner of the patentee has obtained the patent protection with a wrongful intention, then that will become a ground for revocation. The fourth point states that if an invention for which a patent has been claimed is not an invention under the definition of this act, then it will become a ground for revocation. We already know that for a patent to be granted, there are three necessary conditions. First is that the invention should contain an inventive step. Secondly, it should be novel. Third, it should have an industrial utility or industrial application. If these three conditions are absent in any of the patents, then it is one of the major grounds for revocation. In the conditions for patentability, we see that for a novelty to be established, the patent or the invention should not have been published or used anywhere in the world. Otherwise, it is one of the grounds for destroying of the novelty. Secondly, any traditional knowledge is again a ground for destruction of the novelty. The fifth point states that if the complete specification does not describe the best method to perform the invention, then it is again a ground for revocation. We have already studied that for a patent to be granted, the complete specification should be such that the person skilled in the art could develop that invention just by reading that complete specification. If it's not having that feature, then it is again a ground for revocation. One of the feature of a complete specification is that it should specifically describe the scope of the invention. So the sixth point becomes that if a scope of the complete specification is not sufficiently or clearly defined, or in other words, it has a wide scope, then it is another ground for revocation. Seventh point states that if there has been any false information disclosed by the applicant of the patent under Section 8, which pertains to information regarding foreign filings, then it will again be a ground for revocation. Ground 8 for the revocation of the patent states that if any person has contravened any provision under Section 35 while obtaining the patent or has violated Section 39, then it will be a ground for revocation. Section 35 relates to secrecy of patents which are related to the defense. On the other hand, Section 39 of the Act states that any resident while applying for foreign filings has to obtain prior permission from Indian Patent Office. Section 57 or Section 58 relates to amendment of the patent before controller or before the High Court. If any of the applicant has obtained leave to amend by fraud under Section 57 or 58, then it will again become a ground for revocation. If the source of the biological material used for achieving the invention has been wrongfully disclosed or has not been completely disclosed, then it is another ground for revocation of the patent. We all know that as per Section 4 of the Act, any invention falling under Section 20, Subclause 1 of the Atomic Energy Act is not patentable. Therefore, Section 65 states that on the recommendation of central government, the patent of any invention which falls under Section 20, Subclause 1 of the Atomic Energy Act can be revoked. At the same time, Section 65, Subclause 2 states that if the controller deems fit, then he may ask the patentee to amend the specification of such inventions related to atomic energy as per the directions of the central government. Section 66 states that if a patent has been mischievously practiced or is prejudiced to public interest, then central government, after giving due opportunity of being heard to the patentee, may revoke the patent after getting it published in the official gazette. In our next video, we'll be talking about surrender of patents. In the meantime, don't forget to like, subscribe or share this video. If you have any comments, then please drop them in the comment section below. Thank you.